Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are based on our client's income, so the less you make, the less you pay. On today's episode, I wanted to address Rule 17 motions. What is a Rule 17 motion? Well, let's back up for a second and first talk about discovery in a criminal case. So, discovery in a criminal case is basically an exchange of information between the prosecution and the defense. And it's mostly coming from the prosecution to the defense, although the defense has certain items that they have to turn over to the prosecution as well. So, it's information, it's witness statements, it's the police report, it's photographs and video surveillance, um, test results from ballistics tests, from drug tests. It can be any number of things. So it's the Commonwealth, that is the prosecution, is under a duty to give to us the discovery that they have. So they have to give us the information that they're planning on using at trial or could use at trial. So they're under an ethical obligation to give that to us. And the big ones, as I just mentioned, the police report and things along those lines. And even in the police report, oftentimes it'll mention other things that maybe the officer saw or heard about. So there could be witness statements. There could be other witnesses that are involved in something. Video surveillance from from someone's home or from a camera in a store or something like that. So these are the types of things that you're looking for. So they have to turn over everything that's within their care and control, something that what's in their custody that they have. So anything that the police have, that's the whole. So it's the whole government. If the police have it, the prosecution has to turn it over to us. Sometimes there may be some items, some information that we want that the Commonwealth doesn't have in their possession. For instance, video surveillance from a third party. So sometimes in cases, say for example, shoplifting cases, they will have a video surveillance of what they are claiming is showing that you're stealing from the store. Sometimes an officer will view the video surveillance but not get a copy of that directly. So the store is still holding on to this potential piece of evidence. Now, we can't the court can't force the prosecutor to give that to us because they don't have it within their possession. So that's where a Rule 17 motion comes from. So if you're looking for information and possible evidence that is being held in custody, that's being in the possession of a third party, your attorney is going to be filing a Rule 17 motion. And basically, the Rule 17 motion, it's kind of a two-step process. But what you do is you're asking the court to issue a subpoena for that either company or entity to turn over the information that they have to you. So what happens is if that's the first stage. If the first stage is allowed by a judge, a subpoena will go out, and that, like I say, that entity, it could be a governmental entity or a private entity, has to provide that information to you. To us through the court. However, sometimes the people who are holding on to that piece of evidence may feel that they have an objection to that subpoena. So there may be some reason why they don't want to turn it over to you. It could be a confidentiality sort of a thing. So if you're looking for records from someone's therapist, for instance, that may well be protected by the doctor-patient privilege. And if so, then somebody from the doctor's office would object to having that information turned over to us as part of the case. So what happens is the court issues that subpoena, and there's a return date on it. So let's say it's October 15th. It has to be produced, or somebody has to appear from that company or entity to object to the Rule 17 motion. If they have an objection, a hearing will be held. Basically, they'll be saying why they don't want to turn it over, and we would be making an argument about how necessary it is for our case. The judge will make a decision whether or not that information should be turned over to us. So if they don't object or nobody shows up, then that information should have been provided by that date. Tell you the truth, oftentimes it's not. Companies get these subpoenas and it's not a real priority for them. So sometimes we have to go back at them a couple of times to force them to turn over that information to us, because basically it's a pain in the neck for them. They're not getting paid for it. So it doesn't mean that much to them, but it can mean a great deal to us and to you in your case, particularly if it's very strong evidence of your innocence. So that's a Rule 17, sort of in a nutshell. It's a way of getting information and discovery from a third party, something that is outside of the control of the Commonwealth. Now, we always want to be very careful about what we're asking for, because if the Commonwealth doesn't have it, obviously the Commonwealth can't use it against you at time of trial. So it's very important for us to know what that information really will show, because we don't want to go after something, draw the attention of the Commonwealth to that piece of information if it's going to be harmful in our case. Let's take the case of a shoplifting situation. We don't want to order that shoplifting videotape if it's going to show that you're putting things in your pocket and not paying for them. We'd rather they don't have that, because obviously that's a very strong piece of evidence against you. So you want to be careful that you're not opening up a Pandora's box and getting things that are going to be harmful to your case. The first rule is to do no harm. So we don't want to bring in anything that's going to backfire against us. So that's a Rule 17 motion. Can be very, very helpful in many cases, but has to be used wisely so that there's no harm that comes to us as a result of the Rule 17. Again, at Afford Law, we do practice criminal and family law throughout Massachusetts. We do everything on a sliding scale based on our client's income. So our fees are based on how much money you make. The less you make, the less you have to pay. We're trying to give voice to the hardworking men and women of Massachusetts, to give voice to them in the courtroom, because for so long they have been ignored, essentially. So that's us. If you have any questions, please feel free to visit us at affordlaw.org, and we'd be happy to answer any questions. Please feel free to book a free virtual appointment with me. I'd be happy to answer any questions that you might have about any criminal or family law matters, and to give you some more information to see where you stand. At Afford Law, we're making justice affordable. Thank you.